Good morning and welcome to the immigration news for this week. The piece that will be guiding us for this week is taken from freemovement.org.uk. The particular piece that have been selected for this week has to do with one area of UK immigration laws or policies which we believe is very relevant to our people. And it comes under the heading General Grounds for Refusal, Alleged Deception and Innocent Mistakes. Now, I'll take that. Making a mistake on an immigration application form can be disastrous. If the mistake is interpreted by officials as an attempt to mislead or deceive, the application will inevitably be refused. If the application was for entry clearance, it will also lead to a 10-year ban on re-entry to the UK. There are a number of relevant court cases and Home Office policies that can help if such a situation does arise, although, of course, it is far preferable to avoid such a problem in the first place. So this piece has to do with an issue of alleged deception, even if it's an honest mistake. You know, when you put your documents together for an application, either in country or you are coming from abroad, the Home Office officer has to check those documents. If the officer seems to come to a conclusion that any of the information you supplied or any of the documents you supplied is a false document, or that those informations were given in order to deceive the officer into granting you the visa, then it will be refused. We have two sets here. There's a refusal straight on, but if you are coming from abroad, that is the one they call entry clearance. Then you'll also be bound from entering the UK for 10 years. And that's very important because at times there will be a refusal at home for some people that are trying to come into the UK. And that refusal will be based on the fact that maybe the officer does not believe the information you supplied or the document you supplied, and he or she concluded that they are false. Then you leave. Obviously, it's refused. You leave. Then you go on and make another application. What the policy is saying is that that application will be refused for up to 10 years. So making more further application over and over and over would just be a waste of your money. And that's one of the reasons we picked this, so that we understand the way this policy works. Now, what are the immigration rules on deception? I'm going to pick pieces from this whole document so as not to bog you down with lots of policy statements or going into what a particular case law says or does not say. So I'm just going to pick and select. So now, what are the immigration rules on deception? The first thing is automatic refusals. So there are two key effects of a finding of deception. Remember that from the opening page, it could be an honest, innocent mistake, and it could be deception per se. But the determining point is when the immigration official decides that this information is false and is directed at deceiving the immigration service. So it will be, even if it's innocent, if it's an innocent mistake, it will still be taken at that. And we'll come right later on to how you can deal with things like this. So, but the first part is the immigration says that there has to be automatic refusals. So the first one, the application concerned will always be refused no matter what. Whether it's deception by the applicant per se, or a mistake that is honest mistake or innocent mistake, it will be refused. The second part of it, which I think I've explained, is that if the application was for entry clearance, future application for entry clearance will automatically be refused for a period of 10 years from the date of deception. So even after the first refusal, if you now apply with other documents that are okay and fine, the fact that your name appear there, it will be refused. And that will go on for 10 years. So it's quite very important for us to get this. Now, I will quickly go to other part that I think is very, very important for us to understand, because even what is considered to be a deception, it may not come from you. And that is where this thing gets, you know, I won't say interesting, but then it gets complex. Let me look at that. I've got, okay. Now we have these. Does deception have to be deliberate? Deception for the purpose of paragraph 327b and 32211 is defined in paragraph 6 of the immigration rules as making false representations or submitting false documents, whether or not material to the application, or failing to disclose material facts. This definition does not, therefore, include an explicit requirement that deception needs to be deliberate. However, we have case laws, which is through the Court of Appeal, which has held that a deliberate intention to deceive is needed when refusing under paragraph 322A of the immigration rules. More recently, in the case of R. Hager versus Secretary of State for the Home Department, that is first document for people that wants to check, is 2017 UKUT 121AC. The upper tribunal found that for a document to be false document under the provision of the immigration rules at V3.6A of Appendix 5, I find, relying on AA, that's Nigeria, there must have been an element of dishonesty in its creation, and if this is not immediately obvious in a case of an inaccurate document, then that element must be engaged within any refusal. What makes it so that there's an example here, and this is where it gets really complex and where applicants have to be very, very careful with the sort of document they carry on them. Interestingly, for a document to be considered false, there needs to be an element of dishonesty. But this dishonesty does not need to come from the applicant. So that means if somebody else handles your document and there's a form of dishonesty in that document, you may be innocent, you may not even be aware of it, but if that is spotted by the immigration officer, the officer that is dealing with your application, then it will be refused. And it will be refused based on the ground that you want to deceive the UK Immigration Service. So let's take this. We have a case here. In this case, the first document was the appellant's passport, which contained a stamp showing his re-entry in Pakistan 1 month earlier than he actually entered the country. So, on his passport, a month before he entered the country, the stamp that was put in by the Pakistani authorities was that he entered on so date. But I think during the time of interview, when he was asked, he said, okay, I entered on this day. And when it was checked, there was a sort of a difference, a month difference between the time he said he entered and the stamp that is on his passport. So that is taken, while he was not the one that stamped the passport, but then it comes out as a form of dishonesty. So the question was not whether the applicant used deception, but rather whether the Pakistani immigration officer did. If it could be proved that he did, then the application should be refused as a false document had been submitted. This is the second part of what we want to discuss, or what we are discussing now, is that whatever document you are carrying, you need to double check and cross check it. If there are things you are not sure about, because when you submit your application and your document, the officer that will be interviewing you will have gone through those documents. And if there are some disparities there, they will have noted it. But obviously the officer won't tell you straight on. He or she will ask you some further questions. And if those answers you've given do not align with what they have in the document, then it will just be, it will just be refused. And then they will put it as a ground of refusal to be the fact that you want to deceive the immigration service. Now, if there is what is considered to be an innocent mistake, if you were refused based on a falsehood, that you submitted a false document, or that you gave some informations that are not factual, that are wrong, and the officer believes that you want to deceive them, and you know that that's not the case, this is where it's necessary to take an action. Because if you don't take that action, and this is very common with our people, when people are refused a visa on a claim of, they put the grounds of refusal will always be stated there. Some people will just think that, okay, no, I'll just go back and make another application. What happens with the system, the UK immigration system, is that your name is already in the system. So any other application that you submit, they only need to type your name in, and it will come out that you've been here before and you've tried to deceive them. In fact, submitting another application will be seen clearly that, yes, you've gone to package other things that you want to use to establish your deception. So there's no need having to make application over and over and over. If you know there's something that is honest, that you have is honest, what has been claimed against you is not the fact, then you need to challenge the Home Office. I understand that it's not an easy thing to do, because you are going to waste money, you are going to waste time. At times it's a very long journey. At times taking on the Home Office is like groping in a dark tunnel, but if you have it in your mind some people would basically not even think again about coming to the UK, but they will do it in order to clear their names, so that if they want to do anything in the future, because the UK, I know that maybe in some of our communities, records are not kept for that long, but when it comes to the UK and most of the Western countries, they keep records. So your records will be there. 10 years, 15 years after you want to do something, they'll pull out your record. So you need to close that narrative. If there are things that they've alleged that you have used deception, or you attempt to use deception and you know that you have not, then make sure that you challenge the Home Office, and that's the only thing that can clear you. But beyond that, and as a first step, you need to ensure that you have all your documents checked. If you are not sure of something, it is better to say you are not sure, and they could ask for further information, or they will ask you to provide further documents. So that's better, rather than giving a sort of an information where they will come back and they will say, oh, you were trying to deceive us. with this particular information. I'll quickly run through because I don't want this video to be too long. There's some points that have been put here, how to avoid bans based on deception. Just like I've mentioned, double checking applicant forms before they are submitted. They say many clients will tell you that the applications were submitted through agent. This is never a valid reason to submit false or inaccurate information, and the Home Office will always hold them responsible for any information contained in them, as they did. At the end of the day, you signed the form. Obviously, you signed the form, so you have a duty to read through and make sure that all the information in the application is perfect and right. Secondly, paying close attention to potential problem questions like previous convictions and previous immigration history. If in doubt as to whether an issue that arose in the past will be considered a conviction, it will be a good idea to raise it in the application. It is often better to disclose more than less. Of course, in the application, they will ask you whether you have convictions. You need to put it there. It does not mean that because of your conviction, then they will refuse. But if you fail to put those convictions in, they don't even need to check whether those convictions are weighty enough for them to refuse you. The fact that they know you didn't disclose this particular one is automatic refusal. They don't need to continue wasting time on looking at that application. So if you are not sure, ask those that knows the way these things are. In fact, you can even ask the Home Office questions. You can send questions to the Home Office if you are not sure of something that you should put in or not put in. And thirdly, the third one is checking passport to make sure the applicant has not forgotten anything and has given correct dates in relation to past travel history. Don't think about, I think it was on the 10th or on the 12th. Get your documents. Be sure of the dates you are putting in. And, as an extra, ensure that some of the things are in your brain, especially when you are going for interview. So you don't end up putting something in your application and telling them during an interview, you tell them something else. It will be taken that you are deceiving them. Then, of course, the ultimate is telling the truth. If you are telling the truth, you don't have to think over it again. If it's the truth, you say it straight away. If they ask you 100 times, even if you've honestly forgotten some things, it will come out naturally. And we're at 18 minutes. I'll quickly check which one is the last one so that we could finish up with this. Now, the Home Office policies on deception. I'll quickly roll this one out. They say these are examples, but not limited. Fraudulently claiming or otherwise defrauding the benefit system. They will always check that. If you're on benefit or you've made claims, they will check. Secondly, providing dishonest information in order to acquire goods or services. For example, providing false details in order to obtain a driving license. They always check that. Your driving license, they check your national insurance record. At times, your home address and stuff, they check if you are here. Then next one, if provided false or deliberate misleading information at earlier stages of the immigration application process. For example, providing false biodata, claiming to be a nationality you are not, or concealing conviction data. Now, if you have ever, I've always advised people, especially if you are in the United Kingdom, find a means of asking for your file through the FOI, Freedom of Information. I think now you don't even have to pay for it. Write to the Home Office, ask for a copy of your file. When you get a copy of your file, go through it. You'll be able to see the information they hold about you. And on that, I'll be signing out now, and I'll see you next time when we'll be bringing you another interesting and relevant piece to talk about for the benefit of our community.